Good morning, Kamoli. Maybe good afternoon or good night. This is Group 3. Today we will analyze a misconduct case. The case name is Council of New South Wales and Ireland. Our group member is Xiaojun Zhong, Yu Bingteng, Yutong Sun, and Cheng Luyu. Xiaojun Zhong is the first person to introduce the facts and judgment of this case for us.
This case is about that the tribunal finds that the solicitor was sworn in perjury during the proceedings, and the solicitor subsequently admitted that the defense was false. Further, he swore an affidavit to verify his list of documents, including copies of forged letters. Finally, the tribunal points out that the respondent conferred the affidavit in the proceedings before the local court on April 28, which means that the evidence contained therein was and respondent was guilty of professional conduct. In one instance, the letter was supposedly given to the complainant was allegedly drafted on 20 February 2006. However, up to closer inspection, it was discovered that the letter was actually drafted sometime on or after 27 April 2013. For example, in the letter that the supposedly drafted in 2006 contained a reference to the Legal Service Award. During the hearing, when questioned about the discrepancies in the date, the solicitor doubled down on his assertions that it was his understanding that the letter was drafted in 2006, not 2010, creating a letter that is known to contain false information, applies the false letter to the affidavit. When affidavits are affirmed, what is intentionally false, and when accompanied by fabricated documents, is grossly and willfully deviated from the standard of conduct that the public, courts, and practitioners are entitled to expect from legal practitioners. The decision is named removed from the role. The key issue of this case is that solicitor guilty of the professional misconduct, referring to the legal legislation on the slide. The decision is named removed from the role. The key issue of the case is the solicitor guilty of professional misconduct. Refer to the legislation on the slide.
Thank you, Xiaojun. Now let's move on to my part. Today, I will list some factors that did and may have influenced the lawyers and practice behavior. There are a number of reasons could attribute to such professional misconduct. Firstly, it might law firm culture, I think. A favorable law firm culture could bring unnecessary work pressure to lawyers. Under this such pressure, many lawyers could choose to sacrifice their professional integrity to pursue higher efficiency and better outcome. Secondly, it is to hide their mistakes. In the course of legal practice, the carelessness and incompetence of lawyers could sometimes be vital. To not reveal the mistakes they made, sometimes they would fabricate in order to cover them up. Thirdly, it's always the money. Money comes with a positive outcome to make the client more favorable. Unethical lawyers sometimes would do that. If not, fabricate evidence themselves, ask client to do this. After all, there are never good reasons to explain the stupidity of lawyers who put their license at risk just make their side more viable. They should have a look at the ethics of care lawyering approach. Nextly, I will introduce some relevant cases. In the case of Vernon and Bosley, the plaintiff was awarded damage for a stress disorder after he could not rescue two of his children from drowning, which resulted in their nanny driving into the river. Later, the defendant has known that plaintiff had subsequently recovered. Although the plaintiff's lawyers have notice of the situation, they didn't inform in the court. Even though there are some differences between our case, including the purpose of their misconduct, however, in order to make their claim more viable, the plaintiff's lawyer violated honesty and integrity, which is the same conduct as Mark Ireland. Next case is Council of New South Wales Bar Association and Anfield. Anfield was tried due to the speeding fine and lies saying that he was not the driver of the vehicle in question, due to perjuring and perverting the course of justice. Anfield was sentenced to 3 years imprisonment. Similar with the Marks case, both of them tried to hide their mistakes and to avoid on expenditure. As the trained professional, they all did not take on their responsibilities to protect the legal system and the rule of the law.
Thank you, Yutong. Now let's move on to my part. As my group member mentioned before, this case dealt with a solicitor named Ireland who had knowingly fabricated evidence and yet submitted to the court. This led to a serious doubt as to his integrity, which resulted in his name getting removed from the local roll. The court reached the final decision based on following reasoning. To begin with, the court pointed out that there are 3 breaches of professional misconduct in this case. First, the creation of the fabricated letter on 27 April 2013, which is a serious and willful violation of the standards of behavior accepted on legal practitioners. Second, the affirmation of the affidavit, which includes false information on 28 April 2013, which reflects a lack of integrity and credibility, as well as suggests Ms. Ireland is no longer capable to deal with matters fairly. Third, the giving of false evidence on the court, which destroys the character of honesty. The court holds that the situation in this case is similar as in Ian David Plus. That is, these 3 actors should be regarded as a separate and distinct breaches rather than one series of incident evidence. In addition, there is no evidence to support the establishment of good character of Miss Ireland of 2013. Therefore, in order to deter the future manners of Miss Ireland, as well as other practitioners, the court ordered Miss Ireland's name to be removed from the local roll. In my opinion, the tribunal dealt with the issue fairly and reasonably, as it concerned misconduct that was the result of false evidence that was tendered to the court. Miss Ireland has been admitted to the Australian legal profession for about 17 years. I think it is a quite a long time that Miss Ireland should know what the requirements and duties of being a lawyer clearly, as well as the serious consequence of his misconduct. Further aggravating factors included Miss Ireland in question further insisting that the document that was tendered as evidence was genuine, even if the opposite party put him to that it was fake because of the irrationality of the document's content. Miss Ireland could have several opportunities to admit what he did and correct the mistake, but he chose to continue on deceiving the court. I think his acts have a very negative influence on the society, which harms the image and confidence of the lawyer in the public. Although Miss Island finally admitted the forgery and apologized about his act, I think it is too late, and this cannot mitigate the severity of his professional misconduct.
In this scenario, by implementing an ethical decision-making framework, there are 3 steps. First, the respondent should identify his problem. He tried to deny the contract term that he made to the applicant. He is overconfident that he could forge a letter to support his argument based on the fact that the respondent was admitted to practice as a solicitor on 19 April 1996, such that at the time of the event giving rise to the application, he had been admitted to practice for about 17 years. Moreover, he is a partner of a law firm, which means the reputation is very important to him. If the public knows he treated his employee badly, it would probably undermine his business. Second, he should figure out what value he should apply to make this decision. As an experienced lawyer, he should put the legislation like legal professional uniform law, Australian solicitors conduct rules as priorities. He should be honest and courteous. His duty to the court is paramount. Thirdly, he should choose an approach to lawyers' ethics. In this scenario, he values his own reputation and his personal interest more than the justice or public interests. He would rather forge the evidence for the chance that he may win the case than just be an honest person to obey the law. If he chose the responsible lawyer's reasoning, he would try to make law work as fairly and justly as possible. He would definitely not knowingly make false statements. Or he could choose moral activist. He could know he has the obligation to improve access to justice for the public interests. As a professional lawyer, his responsibility is supposed to safeguard justice of the court. Therefore, what he should do is to submit all the relevant evidence to support his side and wait for the court to give the righteous decision. The outcome will be better than what he got now. At least, he would still be a solicitor.